as much as they might, but a good amount of back pay and some certainty going forward that they get fair pay, and that is the right thing to do.
Well, Catherine Delahunty.
Nā koe, Mr Speaker, tēnā koutou te whare. The Green Party is very happy to support the passage of the Sleepover Wages Settlement Bill. We congratulate the service and food workers, Ngā Ringa Tōta in particular, the Public Service Association and Mr Philip William Dixon for their perseverance in a just cause. And we also acknowledge the government for finally making an agreement that may not be perfect, but does address the two fundamental issues of back pay and a process towards the minimum wage for these workers. The Green Party would be a lot happier if the minimum wage payment started now, rather than being phased in by December 25, 2012, but we recognise that a deal's been struck and that this legislation will facilitate the back pay to 30,000 workers who badly need it before this Christmas. The Green Party understand why the government needed to intervene and assist with the back pay, because this has been a long-standing, anomalous injustice which may have overwhelmed IDEA services if they had to pay back the full pay and the minimum wage immediately. But how on earth, Mr Speaker, was it possible that people at work were not being paid the minimum wage for so many years? Did this happen to the firefighters, ambulance officers and resident doctors who also so-called sleep over? Of course not. The reason this was allowed to happen is not pretty. It reflects the values of society rife with both prejudice against people with disabilities and towards carers as a profession. It is treated as low-status job, working with even lower-status people who need and receive skilled and practical support that has been barely valued. When I read what the job involved, it sounded suspiciously like what was once called women's work. All that meal provision, bathing, clothing residence, doctor's appointments, personal care, and all that hard, sensitive, intelligent, and often physical work. And the sleepover, as Grant Robertson has just said, wasn't popcorn. It was about being exploited for doing something so important that most people in this house, I just doubt that we could do it. And at night, the job doesn't stop. People with a range of disabilities or mental health issues need supervision, medication and support 24 hours a day. That is their human right. I'd like to see people like myself cope with the complexity of this work 24 hours a day for less than the minimum wage for half of the time. And less than the minimum wage, Mr Speaker, was $3.77 an hour. Like pocket money, like tokenism, and like an insult to both their work and their responsibilities. And this is for the vital care of citizens whose human rights require us to make sure they have an independent life. So thanks to the advocacy and determination of the unions since 2007 and two legal decisions by the Employment Relations Authority and the Court of Appeal, the legal justification for not paying the sleepover workers the minimum wage disappeared. The Green Party is happy to see the government doing the right thing by the Court of Appeal a judgment, instead of this other piece of legislation we've had before the House tonight, where they're seeking to undermine a court judgment as they're trying to undermine the Supreme Court in the video surveillance monitoring debacle. So now, the 5,000 cases filed by the service and food workers in the PSA can be properly addressed. This law creates a staged progression towards full compliance with the Minimum Wage Act 1983. It has a formula for this progression which starts at 50% of the minimum wage from now till June 30, 2013. Not 2013, that's not right. 75% from June 1, 2012 to December 2012, and 100% of the minimum wage from December 25, 2012 to June 2013. Then the employer must pay an employee for each hour of the sleepover performed by the employee at not less than the rate of the minimum hourly wage rate under the Minimum Wage Act, and that will be about time. The Green Party believes we should lift the minimum wage to $15 an hour immediately and then make it 2/3 of the average wage within 4 years, and it would be great if these workers who've already been discriminated against could have the benefit of a lift in the minimum wage right now. The back pay for these workers has been who have performed Sleepover, as it's called, for the last 6 years, has been calculated by a formula described in the bill as bracket, 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 A times 9, bracket, minus B, bracket, plus C, bracket, X 0.50 plus D. And what does that actually mean? I have absolutely no idea. However, it's interesting to read it in the bill because you think, who made this one up? Was this to help people understand the issues? However, I've got no idea what on earth that formula means in mathematical terms. But I do have faith that if the service and food workers and the PSA and the workers agree that it's a reasonable way to calculate the back pay under the current constraints that they're working with in a very conciliatory and practical way, the Greens are not going to disagree with them about this incomprehensible formula that the government has written into this necessary piece of legislation. Mr. Speaker, sometimes there is really no good excuse for an employer or the Ministry of Health to keep behaving badly. And even though it's going to cost money, as in $27.5 million in back pay and up to $90 million in lifting the wages up to the minimum wage over time, and that's far too much time in my view, they cannot sustain the pretense of or failed argument or denial of what people are doing is actually work. It pains me that the resistance of IDS services and the Crown has wasted money in the court that was badly needed to pay these people the minimum wage now. I don't really see this work as minimum wage work. It's far too hard, it's far too demanding, and it's far too skilled. Any job that involves nights away from home is hard work, but especially broken sleep, responsibility for vulnerable and unpredictable circumstances, and disruptions to your family life under those circumstances. None of that is remotely acknowledged or compensated for by the Court of Appeal settlement yet, or this bill. We have just got to first base. And, Mr. Speaker, I'm hopeful that we can do a whole lot better than just get to first base in our treatment of workers in the next Parliament, should we be lucky enough to be there. Because, really, I celebrate the achievement, but there are so many caveats. These people are still not getting the deal that they really should be getting. We first have to acknowledge that these people have been working all the time. We then need to pay them what they're worth and pay them back what they were worth. None of that is going to happen. Eventually they're going to get the minimum wage. And if you've spent any time with people who are vulnerable in residential care, you will know how complex the job is. And it is somewhat obscene if you've got family members like I have who are cared for by workers who need this kind of who have this kind of job and give that kind of support, that's all they're going to get paid. And to stand here in this House and say, yep, well, eventually you're going to get the minimum wage. Well, whoopee! Because we know what the minimum wage these days will cover. It will not cover your costs. It will not cover your living expenses, and it will not cover the dedication of these workers to the communities who have a right to residential care and independence, but they also need to be respected, as do the workers. Mr. Speaker, I believe that the lack of respect for persons with disabilities and the lack of respect for carers is perhaps one of the most obscene aspects of the 21st century in this country, that we're still fighting for recognition that caring for people is actually as valuable, if not more valuable, than being a banker giving yourself a big fat bonus for playing with other people's money. That's what this should be about, recognising that the people with the skill and capacity to care for others, I think Rodney Hyde told me they're saints, the ones that do special education work, and they don't need a pay rise. But I don't believe that saints don't eat. And I don't even think these people would appreciate being called saints. They would like to be called workers entitled to a wage that reflects the capacity that they show in looking after people in the community that you and I need help to support. So let this be the beginning of an uplifting of their role, their money, their back pay, and all the rest of it. I'm glad we've got here. I'm glad we've got here before Christmas. It's really, really important that these people wait no longer. This is actually a good reason for urgency. Unlike that other bill, which is a shame, a disgrace and an abuse of power, this is a good reason for urgency, Mr. Speaker. It's urgent. Justice is urgent. And so let us have justice. Thank you very much.
Tēnā koe, Mr. Speaker. Kia ora tātou.